Hello everyone, I'm Aratrika Bhaumek and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court and then cover High Courts and other subordinate courts. If you like our content, please do support us by liking and subscribing to our YouTube channel. Let's begin. The Supreme Court of India today allowed the amendments proposed to the Constitution of the Board of Cricket Control of India, that is the BCCI, to relax the mandatory cooling off period requirement. Now the cooling off period of 3 years will apply only if a person serves 2 consecutive terms at the BCCI or the state association. Also, the cooling off period requirement will apply at that particular level, either the state association or the BCCI. In other words, the cooling off period requirement will not bar one from seeking election to the BCCI immediately after serving 2 consecutive terms at the state level. A division bench comprising Justices D.Y. Chandrachud and Hima Kohli passed the order in the plea filed by the BCCI seeking permission to amend its constitution to do away with the cooling off period for holding 2 consecutive terms in the BCCI, in state association or a combination of both. The Supreme Court today continued hearing the batch of petitions challenging the Karnataka High Court's judgment which upheld the ban on wearing of hijab by Muslim girl students in some schools and colleges in the state. Today was the 5th day of hearing by a bench comprising Justices Hemant Gupta and Sudhanshu Dhulia. It also heard Senior Advocate Aditya Sondhi appearing for an intervener and Senior Advocates Rajiv Dhawan and Huzaifa Ahmadi for the petitioners. Ahmadi argued today that the impugned government order against wearing of hijab in schools misunderstands the concept of fraternity and confuses the same as the antithesis of diversity. He submitted that by prohibiting hijab, the state has virtually forced Muslim girl students out of schools. We have made a detailed video on today's hearing, the link to which has been given in the description box below. Revealing a rather unpleasant truth, the Supreme Court of India has lamented that once children are caught in the web of adult criminal justice system, it is difficult for them to get out of it unscathed. A bench of Justices Dinesh Maheshwari and J.B. Pardiwala further observed that awareness about child rights and co-related duties remain low among the functionaries of the juvenile justice system. The court further observed that the main object and purpose of the Juvenile Justice Act should be kept in mind as the focus of the legislation is on the juveniles' reformation and rehabilitation. The court was considering a petition filed by a convict accused undergoing life imprisonment for the offence of murder, seeking to direct the Uttar Pradesh government to verify his exact age on the day the crime was committed. The Bar Council of India has sought the views of the state bar councils, seeking their views regarding allowing a Korean citizen who completed his law education in India to enroll as an advocate in India. The BCCI has sent a letter to state bar councils in this regard, seeking their views and through them the views of the bar associations as well. The issue relates to the enrollment of one Mr. Deong Jung in the State Bar Council of Delhi. The council had also considered the proceedings of the High Court of Delhi in the matter, where according to the council, the court seemed to be inclined towards granting him enrollment. The Delhi High Court today directed former Rajya Sabha MP Dr. Subramaniam Swamy to ensure that possession of his government accommodation allotted to him in 2016 for a period of 5 years is handed over to the estate officer within 6 weeks. Swamy, who has been provided with Z category protection by the centre, was allotted government accommodation on 15th January 2016 on license for 5 years. The premises was allotted to him on account of the threat perception which was assessed by the centre. Swamy then became a member of the Rajya Sabha, which term came to an end on 24th April. While Swamy was serving as a member of the upper house, the government accommodation continued to remain and the allotment ultimately came to an end by the efflux of time. A Hindu worshipper has filed a caveat before the Allahabad High Court in connection with the Gan Vapi mosque case. The caveat has been moved by woman worshipper Rekha Pathak, who was the first petitioner in the suit filed before the Varanasi court by 5 Hindu women plaintiffs seeking worshipping rights inside the Ganwapi mosque compound. The caveat states that if any revision plea is moved before the Allahabad High Court by the Anjuman Islamia Committee's plea challenging the September 12th order of the Varanasi court, wherein the court had found the suit of the Hindu worshippers to be maintainable, then the caveator must be given an opportunity of hearing so as to oppose the plea of the proposed revisionist. The Delhi High Court has stayed the trial court proceedings in relation to an FIR registered over the demolition drive conducted by officials of South Delhi Municipal Corporation in city Shaheen Bagh area in May this year. A single-judge bench comprising Justice Anu Malhotra stayed the trial court proceedings till October 19th. It was alleged in the complaint that while the staff and police personnel were present at the site for carrying out the encroachment removal action, Okhla area's MLA from AAP, Amannatullah Khan, along with his supporters, did not allow the field staff of South Delhi Municipal Corporation in performing their duties. The Delhi High Court has sought the response of the central government as to why no objection certificate has not been issued to Pakistani Hindu migrants residing in city's Adarsh Nagar area without electricity for the last 5 to 6 years. A division bench comprising Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad said that it hopes and trusts that the centre will look into the plight of the migrants sympathetically while directing it to file a proffer affidavit within a period of 2 weeks. In a significant development, the 3-judge bench of the Rajasthan High Court has observed that the use of the word unmarried in Rule 2, Subrule C of the Rajasthan Compassionate Appointment of Dependents of Deceased Government Servant Rules 1996, depriving a married daughter from the right of consideration for compassionate appointment, violates the Equality Clause and thus cannot be countenanced. Notably, Rule 2, Subrule C, which defines dependent, stands amended wherein the married daughter has also been included in the definition, subject to certain conditions. Thank you. Keep watching Courts Today on LiveLaw for more such updates. If you like our content, please do not forget to like and subscribe to our YouTube channel. See you tomorrow.